नमस्कार दोस्तों, लीगल गुरुकुल में आप सभी का बहुत बहुत स्वागत है। दोस्तों आज हम डिस्कस करेंगे मल्टीपल चॉइस क्वेश्चन इंडियन कॉन्ट्रैक्ट एक्ट के। आज इसमें हम जो है क्वेश्चन नंबर 151 से लेकर 200 यानी कि हम 50 क्वेश्चन जो है MCQ के इंडियन कॉन्ट्रैक्ट एक्ट के जो है वो डिस्कस करेंगे। इससे पहले मैं आपके साथ 150 क्वेश्चंस, जी हाँ 150 क्वेश्चंस आपके साथ डिस्कस कर चुका हूँ अलग अलग वीडियोस में। किसी में 25 है, किसी में 50 है। तो अभी तक हम 1 से लेकर 150 क्वेश्चन डिस्कस कर चुके हैं और आज हम जो है फर्दर 50 क्वेश्चंस यानी कि क्वेश्चन नंबर 151 से 200 तक आज हम डिस्कस करेंगे। तो ज्यादा टाइम ना वेस्ट करते हुए चलिए शुरू करते हैं। और इसमें मैं आपको बताना चाहूंगा कि इस वीडियो में कुछ क्वेश्चन जो है कॉन्ट्रैक्ट ऑफ गारंटी के भी जो है वो आएंगे, तो हम उन्हें भी साथ साथ जो है डिस्कस करेंगे। तो चलिए शुरू करते हैं। क्वेश्चन नंबर 151, अंडर सेक्शन 74 द कोर्ट कैन नॉट अवॉर्ड डैमेजेस। ऑप्शन है इसकी ए लेस देन द अमाउंट स्टेटेड इन द कॉन्ट्रैक्ट, बी इक्वल टू द अमाउंट स्टेटेड इन द कॉन्ट्रैक्ट, सी मोर देन द अमाउंट स्टेटेड इन द कॉन्ट्रैक्ट, डी नन ऑफ द अबव। एंड द करेक्ट आंसर इज सी मोर देन द अमाउंट स्टेटेड इन द कॉन्ट्रैक्ट। क्वेश्चन नंबर 52, where the rate of interest prescribed in case of breach is too high, the court can interfere. Option A on the proof of coercion, B on the proof of undue influence, C on the satisfaction that the stipulation is by way of penalty, D on the ground of equity. And the correct answer is C on the satisfaction that the stipulation is by way of penalty. Question number 53. A partnership firm consists of 3 partners A, B and C and owes R a sum of rupees 15,000. A want to retire and it is agreed amongst all the 3 partners and R that after retirement of A, B and C as continuing partners shall be liable for the dues of R. After retirement of A, R sues A for recovery of rupees 15,000. Options A, R has an option to sue the firm consisting of B and C or the retired partner A. Option B, R has right to sue A to the extent of rupees 5,000 being the portion attributable to A. C, R has no right to sue A as after the retirement of A, a new agreement came into being between R and the firm and A stood discharge of his liability towards R. D, R can sue the firm consisting of B and C along with A as liability of all the partners is joint and several. And the correct answer is C, R has no right to sue A as after the retirement of a new agreement came into being between R and the firm and A stood discharge of his liability towards R. Question number 154. The law relating to tender of performance is laid down in Option A, Section 37, B, Section 35, C, Section 36, D, Section 38. And the correct answer is A, Section 37. Question number 155. For a loan when there is stringency in money market, a banker asks for an unusually high rate of interest. A accepts the loan on these terms. This is A valid transaction in the ordinary course of business, B, a transaction vitiated by coercion, C, a transaction vitiated by undue influence, D, a transaction vitiated by fraud. And the correct answer is C, a transaction vitiated by undue influence. Question number 156. A wagering contract is void under Option A, Section 28, B, Section 29, C, Section 30, D, Section 31. And the correct answer is C, Section 30. Question number 157. X and Y agreed to marry each other on a certain date and before that X goes mad. Y cancelled the contract and sued for damages. Option A, no cause of action lies till the date of marriage. B, on account of X going mad, the contract frustrated and void, Y has no right to sue for damages. C, the contract itself is void. D, Y is guilty of breach of contract. And the correct answer is B, on account of X going mad, the contract frustrated and void and Y has no right to sue for damages. Question number 158. A promises to make a sculpture for B. Option A must perform his promise personally. B, A's son can perform the promise. C, A's servant can perform the promise. D, A's employer can perform the promise. And the correct answer is A must perform this promise personally. Question number 159 पे चलते हैं. X, a Delhi merchant and a native of Delhi entered into contract with Y, a Jabalpur merchant, for purchase of 50 quintals of Sitafal. In Delhi, Sitafal is a vegetable, while in Jabalpur it is a fruit. Option A, the term of contract are to be interpreted as per meaning of the proposer. B, the term of contract have to be interpreted as per the meaning of the acceptor. C, the contract is void on account of mutual mistake as to the meaning of Sitafal. D, no concluded contract has come into being as there was no meeting of minds. And the correct answer is C, the contract is void on account of mutual mistake as to the meaning of Sitafal. Question number 160. If a promisee accepts an anticipatory breach committed by the promiser, then option A, the promisee need not perform his part of contract but he cannot claim damages from the promiser. B, the promisee need not perform his part of contract but he can claim damages from the promiser. The promisee, option C, the promisee need not perform his part of contract and can claim damages without wavering till the date of the performance. D, the promisee must perform his part of contract before claiming damages from the promiser. And the correct answer is C, the promisee need not perform his part of contract and can claim damages without wavering till the date of the performance. Question number 161. X enters into contract with Y for which Y is guilty of fraud. X can A, set aside the contract and recover damages. B, set aside the contract but cannot recover damages. C, recover damages but cannot set aside the award. D, recover damages for actual loss suffered. And the correct answer is A, set aside the contract and recover the damages. Question number 162. X agreed to supply 10 tons of coal at Rs 1000 per ton to Y to be delivered not later than 31st January 2017. X also entered into a contract with A for purchase of 10 tons of coal at Rs 800 per ton, telling A clearly that the coal is needed before 31st of January 2017 for supply to Y to fulfill the contract with Y. A fails to supply the coal to X, who in turn fails to supply the same to Y. In an action by X against option A, X can recover damages for the loss of profit at the rate of Rs 200 per ton, that is the loss of profit. B, X can recover damages for the loss or profit he would have earned by timely supply to Y, and also damages which X might have to paid to Y on account of breach of contract. C, X can recover damages which X might have paid to Y on account of breach of contract. D, X can recover damages in the form of penalty. And the correct answer is B, X can recover damages for the loss or profit he would have earned by timely supply to Y, and also damages which X might have paid to Y on account of breach of contract. Question number 163. An offer was sent by post. The acceptor wrote accepted on the letter, put it in his drawer and forgot about it. The transaction is A valid contract, B a voidable contract, C a void contract, D no agreement as the acceptance was never communicated to the proposer. And the correct answer is D, no agreement as the acceptance was never communicated to the proposer. Question number 164. X holds land on a lease granted by Y. The revenue payable by Y to the government being in arrear, the land is advertised for sale by government under the relevant law, the consequent of which is annulment of X lease. X, in order to prevent the sale and consequent annulment of lease, pays the dues of Y to the government. Option A, X is entitled to reimbursement of the amount so paid from Y. B, X is not entitled to anything from Y for want of any contract between them. C, X is not entitled to any amount from Y because X has paid the amount to save his own tenancy. D, X is not entitled to anything from Y as it is a gratuitous act of X. And the correct answer is A. X is entitled to reimbursement of the amount so paid from Y. Question number 165. An employer asks his employee (servant) to sell his servant's good at a price for less than the market price (fair price). Servant can avoid the contract on the ground: A. Undue influence, B. Coercion, C. Mistake, D. Fraud. And the correct answer is A. Undue influence. Question number 166. A agrees to let her daughter B for hire to C for concubinage without the consent of B. The contract is A. Void as the consent of B the daughter has not taken, B. Void being immoral, C. Voidable at the instance of B, D. Valid as A and C entered into contract with their free consent. And the correct answer is B. Void being immoral. Question number 167. X in consideration of rupees 10,000 lent by Y and Z provides Y and Z jointly to repay them that sum with interest on a specified day. Y dies. The right to claim performance A is available to Y's representative alone, B is available to Z alone, C is available to Y representative and Z both, D is available to Y representative and after the death of Z his representative. And the correct answer is C is available to Y representative and Z both. Question number 168 पे चलते हैं. The doctrine of impossibility of performance rendering contract void is based on A. Implied terms, B. Just and reasonable solution, C. Supervening impossibility, D. Unjust enrichment. And the correct answer is C. Supervening impossibility. Question number 169. The age of majority for the purpose of Contract Act is A. 18 years, B. 21 years, C. 16 years for girls and 18 years for boys, D. 18 years for girls and 21 years for boys. And the correct answer is A. 18 years. Question number 170. A contract signed between two countries without specifying as to which country's law shall govern in cases of dispute. A. It shall be governed by the law of the country where the proposal was made. B. It shall be governed by the law of country where the contract was concluded. C. It shall be governed by the law of country which the parties intend to apply, that is where the contract is localized. D. It shall be governed by the law where the contract is performed. And the correct answer is C. It shall be governed by the law of country which the parties intend to apply, that is where the contract is localized. Question number 177. The damages under Section 73 of Indian Contract Act are A. Liquidated, B. Compensatory, C. Penal, D. None of the above. And the correct answer is B. Compensatory. Question number 172. While determining damages, which of the following are taken into account? A. Motive of breach, B. Manner of breach, C. Inconvenience caused by negligence, D. All of the above. And the correct answer is inconvenience caused by negligence. Question number 173. Which of the following is not relevant in determining quantum of damages? Question number 173. Which of the following is not relevant in determining of quantum of damages? Option A. Motive, B. Manner, C. Loss suffered, D. Both A and B. And the correct answer is A. Motive. Question number 174. Pre-contract expenditure may be recovered as damages. A. Generally, B. Always, C. Only if it is within the contemplation of parties, D. None of the above. And the correct answer is C. Only if it is within contemplation of the parties. Question number 175. Duty to mitigate damages on part of injured party arises A. In case of anticipatory breach, B. In case of breach at the time fixed for performance of contract, C. Both A and B, D. Either A or B. And the correct answer is D. Either A or B. Question number 176. A sum fixed beforehand as amount of compensation payable in the event of breach of contract is called A. Liquidated damages, B. Penalty, C. Either A or B, D. Neither A or B. And the correct answer is C. Either A or B. Question number 177. The essence of liquidated damages is A. Genuine pre-estimate of damages, B. Less than probable damages, C. More than probable damages, D. Payment of money in terrorem. And the correct answer is A. Genuine pre-estimate of damages. Question number 178. A contract of indemnity as a contract by which one party promises to save the other party from the loss caused to him by the conduct of the promisor himself or of any other person has been defined A. Under section 124, B. Under section 123, C. Under section 125, D. Under section 126, and the correct answer is A. Under section 124. Question number 179. A contract of guarantee has been defined A. Under section 123, B. Under section 124, C. Under section 125, D. Under section 126, and the correct answer is D. Under section 126. Question number 180. Surety is a person A. in respect of whose default the guarantee is given, B. who gives the guarantee, C. to whom guarantee is given, D. none of the above, and the correct answer is B. who gives the guarantee. Question number 181. Creditor is a person A. to whom the guarantee is given, B. who gives the guarantee, C. in respect of whose default the guarantee is given, D. none of the above, and the correct answer is A. to whom the guarantee is given. Question number 182. A guarantee, option A, has to be in writing, B. can be oral, C. can be oral or in writing, D. neither A or B. Correct answer is C. can be oral or in writing. Question number 183. Liability of surety is A. conditional on default, B. independent of default, C. can be conditional and can be independent, D. neither A or B. Correct answer is A. conditional on default. Question number 184. A valid guarantee can be given A. only if there is no principal debt, B. only if there is principal debt, C. irrespective of any debt, D. both A and C, and the correct answer is B. only if there is principal debt. Question number 185. A guarantee to be valid A. can only be of a present debt, B. can be of past debt if some further debt is incurred after the guarantee, C. can be of future debt if some debt is incurred after the guarantee, D. all of the above, and the correct answer is D. all of the above. Question number 186. A guarantee obtained by misrepresentation or concealment is A. invalid, B. valid, C. voidable, D. illegal, and the correct answer is A. invalid. Question number 187. Which of the following is a valid guarantee? A. guarantee of a minus debt, B. guarantee of a debt of a company acting ultra vires in obtaining the loan, C. both A and B, D. neither A nor B, and the correct answer is A. guarantee of a minus debt. Question number 188. The liability of a surety, option A, is coextensive with that of principal debtor, B. extends to the whole of the amount of which principal debtor is liable, C. both A and B, D. neither A nor B, and the correct answer is A is coextensive with that of principal debtor. Question number 189. Under the contract of guarantee, the liability of surety A. can be limited, B. cannot be limited and has to extend to the whole amount due from principal debtor, C. can be extended to penalties also, D. both B and C, and the correct answer is B. cannot be limited and has to extend to the whole amount due from the principal debtor. Question number 190. A guarantee which extends to a series of transactions under section 129 is called A. an absolute guarantee, B. a continuing guarantee, C. an invalid guarantee, D. a conditional guarantee, and the correct answer is B. a continuing guarantee. Question number 191. A continuing guarantee applies to A. a specific transaction, B. a specific number of transactions, C. any number of transactions, D. reasonable number of transactions, and the correct answer is B. a specific number of transactions. Question number 192. A continuing guarantee under section 130 is A. recoverable absolutely, B. irrecoverable absolutely, C. recoverable as regards future transaction, D. either A or B, and the correct answer is recoverable as regards future transaction. Question number 193. The liability of surety on his death under section 131 in case of continuing guarantee. Option A is terminated absolutely. B does not stand terminated as regards past transaction. C stands terminated as regards future transaction. D both B and C. And the correct answer is C stands terminated as regards future transactions. Question number 194. The surety stands discharged. A by revocation, B by death, C by variance in terms of contract without his consent, D all of the above. And the correct answer is by variance in terms of contract without his consent. Question number 195. Under the contract of guarantee, a creditor A has to avail his remedies first against the principal debtor, B can avail his remedies against the principal debtor as well as surety, C can avail his remedy against the surety alone, D both B and C. And the correct answer is A has to avail his remedy first against principal debtor. Question number 196. Surety stand discharged. A by an agreement between creditor and the principal debtor, B by an agreement between the creditor and the third party for not to sue the principal debtor, C both A and B, D neither A nor B. And the correct answer is A by an agreement between creditor and the principal debtor. Question number 197. Under a contract of guarantee, A if principal debtor is not liable, guarantor is not liable. B if principal debtor is not liable, guarantor is liable. C if principal debtor is liable, guarantor is liable. D all of the above. And the correct answer is C if principal debtor is liable, guarantor is liable. Question number 198. In a contract of guarantee, A there are two parties and one contract. B there are two parties and two contract. C there are three parties and three contract. D there are three parties and one contract. And the correct answer is C there are three parties and three contract. Question number 199. In case of co-sureties, release of one surety by the creditor, A amounts to discharge of other sureties, B does not amount to discharge of other sureties, C amounts to discharge of sureties so released vis-a-vis co-sureties as well, D none of the above. And the correct answer is B does not amount to discharge of other sureties. Question number 200. On payment or performance of the liability, the surety A is invested with all the rights the creditor had against the principal debtor. B is entitled to every security which the creditor has against the principal debtor. C is entitled to be indemnified by the principal debtor. D all of the above. And the correct answer is A is invested with all the rights the creditor had against the principal debtor. तो ये हमारे क्वेश्चन थे आज के MCQ के 50 क्वेश्चन हमने डिस्कस किए हैं और मैं अभी अलग अलग जो है टॉपिक्स पे और क्वेश्चन बना रहा हूं, तो जल्दी ही आपको और क्वेश्चन देखने को मिलेंगे। यदि आपको मेरी वीडियोस पसंद आ रही हैं तो प्लीज 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 लाइक करिए, सब्सक्राइब करिए, कमेंट करिए। आपकी बहुत सी क्वेरीज मुझे मिल रही हैं और मैं आशा करता हूं कि मैं आप सभी की जो है लीगल जो भी प्रॉब्लम्स हैं उनका सही तरीके से जवाब दे पा रहा हूं और आप लोगों का प्यार ऐसे ही बना रहे। अगली बार हम फिर मिलते हैं, तब तक के लिए धन्यवाद। जय हिंद।